Hello, I'm MaryJo Webster. I'm a board member on the Minnesota Coalition on Government Information and also a data journalist at the Tribune. This video is going to give you the highlights of the Minnesota Government Data Practices Act, which is Minnesota's public records law. All that information on the Data Practices Act is in Chapter 13 of the state statutes, and it applies to state and local government entities with a couple of exceptions. The big one is the state legislature. The court system is also not subject. However, they do have their own set of rules of access. Also, non-urban townships are not required to follow the law. Any townships that exist inside the Twin Cities metro area are subject to the law. So it does include public K through 12 school districts, not the private ones though, and at the same time, the public colleges and universities, but not the private ones. It may apply to a business or some other private entity that has a contract with the government. It would be a limited application, of course, related to that contract. And then legislators themselves, even though the legislature is not subject, the individual legislators are subject to certain provisions that govern elected officials and candidates for the office. The DPA applies to all government data, and that could be any kind of format: paper, spreadsheets, big database systems, audio, video. It does not matter about the format. Anything that is created and maintained by those government agencies that are subject to the law, the DPA then applies. The general rule of thumb, although this is not how it's written in the law, but this is kind of what you can set your brain to be thinking about, is that all government data are considered public unless otherwise exempted in the law. So the most important thing, though, is that it's up to the agency. They're responsible for proving to you and citing the specific statute in Chapter 13 whether something is not public. Now, it is also possible that the FERPA, which relates to school privacy, and HIPAA, healthcare privacy, could come into play as well, but it's still up to the agency to tell you why something is not public. Also, records retention policies can come into play when you're requesting something, especially something that is, older. Maybe they weren't required to maintain that information any longer and no longer have it. As I said, like earlier, if they have it in their possession, that's a huge part of it. Now, if you are the subject of the data, rules are different, and this video is not going to go into that. This is going to focus on a citizen or a journalist asking for public data on some issue or something that's going on, and it's not data about themselves. Your rights. You have a right to inspect, just look at public data at reasonable times and places at no cost. So if you ask to inspect something, then you would work with that agency to set up a time for you to go to their designated location to be able to look at that, whether it's on paper or maybe via a computer terminal, and they cannot charge you for that. Generally, it's going to be during business hours and at the place that they designate, but it also needs to be reasonable. You also have a right to get copies of public data upon request. However, you might be charged for that, and we're going to talk about the cost factors in a little bit. And by copies, that could be a photocopy and you get a piece of paper. It might be a PDF that gets emailed to you. It might be a spreadsheet. It might be a data file that you can open in various pieces of software. Audio, video, those kinds of things are subject to the law as well, so it could be something like that. And you also have a right to be informed of the meaning of public data. So you might get a spreadsheet with a whole bunch of numbers and pieces of information, and if you don't know what that means, they're responsible to help you understand it. You also have the right to access data and make a request without telling them who you are or why you want to access the data. Generally, it does help to be transparent and tell them who you are, but you don't have to. As I said earlier, you also have the right to be told what state statute or federal law prevents access. The state agency can't just say, you can't have that, or it's not public, or the privacy laws come into play. They have to be more specific and give you the exact statute. So the government agency's responsibilities, they're required to maintain public records in a way that is easily accessible. Now, this is not defined very well in the law, but the idea is that it should be accessible and they should be able to make a copy of it or make it available for you to inspect quite easily. Also, they're supposed to receive and comply with public requests in an appropriate and prompt manner, and they may only charge the actual and reasonable costs of searching and retrieving data and providing copies. Again, we're going to come back to that a little bit. And if you ask for it in a format that it is already kept in, so for example, if they have an electronic file of a document that you're requesting and you ask for it in an electronic format, such as a PDF or a Word document or something like that, but they give it to you in paper, they'd be violating the DPA. As you'll see in another video I'm doing about how to write your letter, you do want to make sure you specify what format you want it in, or that even if you just say, if it's available in electronic format, that is what I prefer. Some key points. So agencies are not required to create new data. So for example, let's say the agency has data on each bill or invoice it paid, but it doesn't have a document or a spreadsheet or anything like that that summarizes the various expenses that they incurred. So in that case, you can ask for all the bills and the invoices, but if they don't have it, if they don't already have it created, they can deny you. The DPA is not used for getting answers to questions. It's for getting those documents or data or any other government items that are already created. So let's say you want to know, how much did the agency spend on toilet paper last year? You'd have to ask for the data on all the invoices that are paid and then do that math yourself. So sometimes you have to think about, maybe there is truly one question you have, but when you want to request something through the DPA, you have to think about what materials, documents, data, videos, recordings, emails, memos, reports, anything that that agency might have in its possession that would give you that answer or help you get to that answer in some form or fashion. Now, the other thing is that in those various situations where detailed data is not public, you can ask for summarized data, and they're required to give that to you. So, for example, the State Department of Human Services, for example, does a lot of work around drug and alcohol treatment, foster care situations, a lot of things where privacy really comes into play for the people that they are serving. And so they might be able to tell you how many people received services for something or another, but only in that summarized way, no details about each individual. So some of the areas where you'll typically encounter some of the exemptions in the law: disciplinary and performance records regarding personnel. However, there are some big situations where, depending on how public that person is, how much of a figure that person is, you might be able to get things. That one's a complicated one. An open, ongoing criminal investigation is one that we run into a lot, especially as journalists. Until that criminal case is closed, a lot of, but not all, of the information regarding that are not public. Student level education records, patient healthcare records, that's where FERPA and HIPAA also come into play. In Minnesota, 911 audio recordings are not public, but you can get a transcript of the call. And juvenile criminal records are also not public. There are some exceptions regarding 16 years old and over, but this is also a sticky area where there's a lot of stuff you can't get. All right, the cost. As I said earlier, inspection is always free. So if you ask to inspect, you can go to that agency and look at whatever it is you've requested, and they can't charge you for that. They may charge a limited amount for a copy of a report or data, a spreadsheet or something like that. One of the big things is they can never charge for the time that they spend redacting. So let's say you ask for a report, for example, a police report that involves a sexual assault case. they need to go through and redact the names and anything else that might identify the victim. The time that they take to black all that out, they can't charge you for that. And there's other situations where maybe a data set has 5 fields of information that is public, but there's a 6th one that is not public. They can withhold that, but they can't charge you for any time it took to leave that out. The rules around charging depend on whether you're getting paper copies or if it's something electronic. Paper copies, 100 or fewer black and white pages, they can charge no more than 25 cents per page. So that's a real easy one. It's really straightforward and clean and easy to figure out what you should be charged. When you get into electronic data, especially something that might come in a spreadsheet or they're extracting it out of a database system, that's where it gets a little trickier. And the rule is that they can charge you the hourly rate of the lowest paid person capable of doing the work. And that doesn't necessarily mean that's the person doing the work. So even if the head of the department does the work, they can only charge you the hourly rate of the lowest paid person in that department who would be capable of doing that work. Now, they can charge for that time that it takes them to search and retrieve and to make a copy. So when we're talking about electronic data that you might get in a spreadsheet, that's usually the time it takes that computer person to write a little bit of code that extracts that information and spits it out as a file that you could open in Excel or some other computer program. The two different things, the paper and the electronic part, I've run into numerous situations like this one where the agency kind of confounds the two things. And in this case, they said they were going to charge me a per page rate. And then they also said, we're going to charge you this hourly amount for pulling the data and providing it in Excel. And really, they can only charge me for that hourly rate of retrieving the data. It has nothing to do with the number of pages. As you can see, they're saying we have approximately 59,500 parcels, so it'll end up being 119,000 records for the 2 years that I asked for. And so approximately 40 records would fit on each page, so that would be 2,975 pages. This is coming in an Excel file, so it has nothing to do with pages. So all they can charge me is that 1 hour at $50.27 for the total hourly cost of the staff who would perform the work. So now the other thing is, how quickly are they supposed to get back to you and get you your requested materials? Minnesota's DPA simply says within a reasonable time. It doesn't set any rules about that. Some other states do have rules, like California has a rule that the agency has to at least respond to you and say they're working on it within a certain number of days. And then they're supposed to finish it up within another certain amount of days. Minnesota doesn't have anything like that. This Commissioner of Administration, there's an office called the Minnesota Data Practices Office, which we'll talk about in a minute. There are opinions that have been issued by the commissioner that help define some of these sticky questions related to the DPA. And there are several that have laid some general boundaries regarding this reasonable time. And generally it says it really depends on the scope of the request. So, one of those really large database requests that I often put in, it's not unheard of that it could take 6 months. That's kind of my rule of thumb when it starts going beyond that, when maybe it is getting beyond the reasonable time. But let's say you ask for police incident data, which is supposed to be available immediately. That should be available that same day or the next day at the latest. What I run into a lot is that, especially with these database requests, is that agencies might have staffing issues, or there's only one person at the agency who can do the extract that I need. Some agencies have a large backlog of requests, and you end up getting into the queue and you just have to wait because there's a lot of other people ahead of you. And so there could be many number of things that could lead to delays. The law really doesn't give you much recourse on this. So let's say an agency denies your request outright or leaves out part of it. The first thing you should always do is make sure that you get an exact citation from Chapter 13, exempting the data you're asking for. For example, I had requested from the State Department of Public Safety a data set on all the car crashes in Minnesota or vehicle-related crashes. And I knew this data set would have crashes where someone died or was injured or major property damage. I knew that the data set existed and what the name of it was because they kept it on their website. And when I requested it, they said it was not public. And then I asked for the citation of the statute, and they gave me the citation where it does say that this data set is not public. So they copied and pasted it into an email. I went out to Chapter 13 and found that section that they gave me and confirmed, yep, that's what they gave me. But then right below the stuff that they gave me was a provision that said, an anonymized version of this data may be made available to the public. And so I sent that back to them and I said, well, this is what I'm asking for, is this anonymized version. And then they were like, oh yeah, you can have that. So you should become comfortable with the Chapter 13, spend a little time looking at it, and then make sure you get those statutes when it's time. And then they're required to put that in writing, even if your original request is not in writing. And if you do need to fight this in anything beyond just you going back and forth with them, you will need this in writing. So make sure you get it in writing just to be safe. And if you aren't already dealing with the responsible authority for that agency, be sure that you include that person in the correspondence. So every agency in Minnesota is required to have a person who's the designated responsible authority, and that's an official term. And they should be fully up to speed on the DPA and their responsibilities around it and how the DPA works. I find this is in cities, this might be a city clerk. In a sheriff's department, it's probably the sheriff, but not always. But this is supposed to be listed on their website. Or you should be able to call the main number and ask who the responsible authority is for the Data Practices Act. So when you're fighting a denial, if you aren't already dealing with that person, you want to make sure that person is looped in. I've had some situations where, I was not dealing with that responsible authority, but then once I included them in the emails and said, hey, responsible authority, so-and-so, please confirm that this truly is not public and give me the statute that says it's not. And oftentimes that will break the logjam. If none of those things are working, you might want to head to the Data Practices Office. Two things is, one, you could do some homework yourself on their webpage, or the others that you could reach out to them, and their contact information is on their website. The main thing that will help you here is that, first of all, they have a bunch of resources that might be useful above and beyond what I've taught you here. But the other thing are these advisory opinions that I mentioned earlier. So anyone, and you don't even have to be a lawyer, can request an advisory opinion on a public access issue. And they also do opinions on public meeting law related issues. For example, a lot of these opinions will be something like, did the county board violate the Data Practices Act by refusing to release such and such a document? And then the commissioner will weigh in and answer that question, and then lay out kind of the parameters of why it was a violation or why it was not a violation. And these advisory opinions are all on this website, and they can be super useful in helping you break a stalemate with another agency, because you might be able to point to an opinion and say, hey, look, this opinion from such and such a year is very similar to what I'm asking for, and the commissioner found that this data was public. I've found there's several, as I mentioned earlier, there's several related to the cost, and I've been able to point agencies to those opinions and say, according to these opinions, you can't charge me for that. The advisory opinions are totally searchable on this website, and they're kind of indexed based on different categories. But if you're struggling to find things in there, you can also ask for help from the Data Practices Office. I've had great luck with them. They'll email me the link to the specific advisory opinion that I might need, and possibly even offer some other suggestions for help. They also do trainings for both government entities and the public on the Data Practices Act. And like I said, you don't have to be a lawyer to request one of these. These opinions are a rarity. A lot of states don't have anything like this. most states rely on their attorney general to kind of step in and weigh in. This, I feel like, is kind of a lower bar to get over and is more helpful. It's quite easy to get a commissioner's opinion. The office staff are helpful to help you with your requests. So let's look at a couple of examples. We frequently, there's a lot of requests for law enforcement data, and the Data Practices Act is actually very clear in Section 13.82 about 3 types of law enforcement data that are available, generally public, pretty much right away. And remember I said at the beginning that the general rule of thumb is that data are public unless exempted in the law. This section actually is kind of the reverse. It lists what is public and when it's public. And I recommend, especially to the reporters I work with, that this section is one you should either memorize or carry a copy around, or make sure you have it bookmarked, because you can literally just copy and paste out of this section and say, here's what I want, when you are trying to get some of this data. So like I said, there's kind of 3 levels. The first is what is known as a request for service data. So this is related to, let's say an incident occurs and the police are dispatched to the scene. That's a service, a request for service. And so there's a handful of things that you can get immediately. And it might not tell you a lot about that incident, but it's going to tell you things like possibly the address. There might be some exceptions, kind of some nature of the request or the activity complained about, time and date, and when they arrived, and then, of course, an incident report number that you can use for future requests. Then there's what's known as response or incident data, and this is usually what police or sheriff's department will create. They're making a report based on that incident. Now, this should be public, but an agency could temporarily withhold it to protect the safety of an individual, or if the release of that information could cause a perpetrator to flee. But they're required to make a statement to that effect. It's not something they can just tell you. If you go to 13.82 subdivision 6, there's a list of all the specific things they're required to provide. And essentially it could be you could use that in your request letter to say, I want all of these things about the incident. And the third one is arrest data. So if they arrest someone related to an incident, there's some basic information that is public at all times, even if an investigation is still active. And now this is an arrest of an adult, of course. As I mentioned earlier, juveniles are handled differently. So this does not apply to juveniles. And again, there's a detailed list of what they are required to provide. One of the big ones we as journalists like is the actual investigative data, the reports that the detectives wrote up and transcripts of interviews and the real nitty-gritty details of the investigation. That is not public until the case is no longer active. And it is quite possible that a case could be held open for a very long time. It could be years or decades even, if it's a cold case, for example. But once it is closed and no longer active, or I guess the correct way is really that it's no longer active, then you do have access to those documents. There are things that can be redacted. For example, I mentioned earlier, information that might identify a sexual assault victim or a undercover detective or something like that. Another one that we commonly see is government personnel data. And again, the DPA section 13.43 actually lists out this huge long list of pieces of information that you are allowed to ask for. And I've just jammed them all in here just to help show you how big this list is. And this isn't even the whole list, but a lot of that basic information, salary and their job title and the bargaining unit that they might be in, a description, their education and background, dates of they started employment and ended employment and things like that. It's all here, and it's super useful. There is also in that same section of the DPA are a ton of details regarding disciplinary data. And kind of the bottom line is that you're allowed to know that there exists, like complaints exist and what the status of that is. If there's a disciplinary action, then there's more data that you can get. But if there is not a disciplinary action, then there's not much you can get. There's some things regarding, like, if there's an agreement to settle some problem. There's some things regarding if it's a very high profile figure, like the head of a state agency, that then things might get different. And like I said earlier, this is a really complicated thing, and I'm not going to go too deep into it, but there's a lot there. Another thing we encounter occasionally is, let's say a city council is producing a report of some sort, and they're circulating a draft copy among city council members, but you ask for that copy of that draft and you were denied. They said it didn't qualify as an official government document yet. Well, that's not true. If it's been created, even if they have not put their rubber stamp on it, that it's finished, it is a public document, a government document in the eyes of the DPA, and then it would be public unless there's some other thing that exempts it from being public. But most of the time it should be something you can get right away. Those are some of the big examples. There's, of course, many more things, but hopefully this gives you a good overview of the DPA.